The ruling landed like a thunderclap on the final morning of the Supreme Court term, and within minutes Washington was in full-blown spin mode. One side shouted total victory. The other warned of a presidency drifting beyond accountability. But buried inside the opinion was the part that could change everything. Because this decision was never just about Donald Trump. It was about what future presidents can do, what they can't do, and where the legal line gets drawn when power, politics, and personal conduct all collide. The court said former presidents do have immunity for official acts. That much is true. But the part getting lost in the noise is just as important. There is no immunity for unofficial, private conduct. None. And that single distinction is where this story gets a lot more complicated than the instant hot takes made it sound. At first glance, you could see why Trump and his allies moved fast to frame it as a massive win. The phrase presidential immunity is explosive. It sounds absolute. It sounds sweeping. It sounds like the kind of ruling that shuts the courthouse doors and wipes away legal danger in one stroke. That's the image many supporters embraced almost immediately. But when you slow down and actually follow what the justices did, the picture shifts. The court did not give a former president blanket protection for everything done while in office. It created a dividing line. Official acts receive protection. Private conduct does not. Then it sent the case back down so lower courts can sort through the allegations one by one. And that is where the real drama starts. Because now the question isn't simply whether a president has immunity. The question is what counts as official presidential conduct, and what looks more like personal political activity carried out by someone who just happened to occupy the Oval Office. That distinction may sound technical. It isn't. It could decide which allegations survive, which evidence matters, and whether some of the most serious claims in the election interference case remain exposed to prosecution. You could feel the tension in the legal world almost immediately after the ruling. Commentators were racing to summarize it before the ink was dry. But a lot of those early reactions flattened the decision into something simpler than it really was. Some treated it like total protection. Others treated it like a complete collapse of accountability. Neither version fully captures what happened. What actually happened is more consequential, and in some ways more unpredictable. The court's majority laid out a framework. Certain core presidential functions are protected. Some other official actions may carry what's called presumptive immunity, meaning prosecutors face a higher hurdle if they want to challenge them. But for private acts, the shield disappears. That means the legal battlefield now shifts to classification. Every major allegation has to be examined through that lens. Was this an official function of the presidency? Or was it a private effort, political in nature, outside the protected role of the office? And once you ask that question, some of the conduct that has received the most public attention begins to look very different. Take the conversations involving the Department of Justice. The court viewed those as tied closely to presidential authority over the executive branch. In plain English, that means discussions with DOJ officials may sit inside the strongest zone of immunity. Whether people like that outcome or not, that appears to be one of the clearest protections recognized by the ruling. So yes, in that category, Trump appears to have gained something meaningful. But that's only one part of the larger picture. Because the allegations that have generated the deepest controversy, the fake elector effort, pressure on state-level officials, coordination with campaign lawyers, and activity surrounding the effort to challenge certification, do not fit as neatly into that protected executive branch box. And that matters a lot. If conduct runs through campaign channels, private attorneys, political operatives, or state-level actors outside formal presidential authority, the argument for immunity becomes much weaker. In some instances, based on the court's framework, it may disappear entirely. That's the part many people either missed or chose not to emphasize. The fake elector issue is a major example. Reports and court filings have described a network of campaign-connected efforts, private legal theories, and state-level political maneuvers aimed at putting forward alternate slates. That is a very different setting from a president directing official executive branch business. It doesn't automatically answer every legal question, but it pushes the conduct toward the private side of the line. And if a court ultimately sees it that way, immunity won't protect it. The same tension shows up in alleged pressure on state officials. A president speaking in an official capacity is one thing. A candidate or political figure allegedly trying to influence state-level certification processes for personal electoral benefit is something else entirely. The legal fight now centers on which description a court finds more persuasive. Then there's Mike Pence. The court suggested interactions involving the vice president could fall into a more complicated zone, what legal analysts describe as presumptive immunity. That does not mean automatic protection. It means there is a starting assumption in favor of immunity, but not an unbreakable one. Prosecutors may still try to argue that certain conduct, even if wrapped in official-looking language, was not truly part of a legitimate presidential function. And that's where this ruling becomes less like a finish line and more like the opening scene of a new legal war. Because every allegation now has to be filtered through this framework. Every conversation, every alleged act, every attempt to separate official duty from private ambition. That process takes time. A lot of time. Which is one reason so many observers quickly concluded that this ruling makes a trial before the election far less likely. That timing question is politically enormous. Even if the ruling doesn't erase all legal exposure, it changes the clock. It adds another round of litigation, another layer of argument, another chance for appeal. So even where prosecutors may still have viable claims, getting to a final courtroom reckoning becomes slower, messier, and far more uncertain. And that may be one reason the celebration came so quickly. Because in high-profile legal and political fights, delay can matter almost as much as victory. Still, the long-term impact may be much bigger than the short-term political spin. For the first time, the Supreme Court has drawn a national rule that says former presidents have immunity for official acts, but not for private conduct. That is now part of the legal landscape for every future occupant of the White House. Not just Trump, every president. That means this ruling cuts in two directions at once. On one hand, it expands protection for official presidential action in a way critics say is historically significant. Some have argued the decision creates a dangerous buffer around the exercise of executive power. You can hear that fear in the public reaction, in legal analysis, and especially in the dissents, where concerns were raised about how far this immunity principle could reach. On the other hand, the ruling also rejects the idea that a former president receives total criminal immunity for everything done while in office. And that matters just as much. The court did not say presidents are beyond prosecution in all circumstances. It said the opposite for private conduct. That's why the triumphal message of case closed may be far too simplistic. If the lower courts determine that substantial portions of the alleged conduct were private, campaign-related, personal, or political rather than official exercises of executive power, then those allegations remain exposed. In that scenario, the legal danger doesn't vanish. It narrows, shifts, and potentially becomes more focused. And in some ways, a more focused case can be more powerful. Imagine the lower court stripping away certain official act allegations while leaving behind a core of conduct tied to private political efforts. That would mean prosecutors are no longer trying to fight through the whole cloud of presidential authority. They would be left arguing over conduct the Supreme Court itself said carries no immunity. That possibility is exactly why this ruling is so hard to reduce to one sentence. It is neither the absolute shield supporters claimed nor the total collapse critics feared in the first wave of reaction. It is a structural reset. It forces the legal system to sort presidential behavior into categories, and those categories could determine the fate of one of the most consequential criminal cases ever connected to a former president. And that brings us to the bigger question hanging over all of this. What does official really mean when politics and power are intertwined? Presidents speak constantly. They pressure, persuade, negotiate, and advocate. Some of that is clearly part of the job. But when the objective appears tied to personal political survival, campaign interests, or efforts outside established governmental channels, the legal ground starts to shift. The title of president does not automatically convert every action into protected state business. That's the unresolved tension at the center of this case. Was this the machinery of government in motion? Or was it a private attempt to achieve a political end using influence, loyalists, and informal networks? That is the battle now moving back to the lower courts. And unlike the loud instant reactions that exploded online, judges will have to examine specifics. Not slogans, not campaign messaging. Specifics. Who was involved? What role they held? What authority was being used? What the purpose was? Whether the conduct ran through official channels or private ones? Whether it resembled governance or political operation? That line-drawing process could become one of the most important legal exercises in modern presidential history. Because once courts start defining those boundaries, They won't just be deciding Trump's exposure. They'll be shaping the playbook for every administration to come. Future presidents, future investigators, future prosecutors, future constitutional fights. All of them will be living inside the framework this case creates. And that may be the most underappreciated part of the story. This wasn't just a ruling about one man's legal strategy. It was a ruling about the future architecture of presidential power. If broad categories of conduct are treated as official, presidential protections grow stronger. If courts decide that campaign-style pressure, back-channel political coordination, and personal electoral maneuvers are private conduct, then the legal system is drawing a hard line around misuse of office. That's why the lower court proceedings matter so much now. They may not have the instant drama of a Supreme Court announcement, but this is where the ruling becomes real. This is where abstract doctrine turns into consequence. And make no mistake, there will be fierce arguments over every inch of that terrain. Trump's legal team is likely to push for the broadest possible reading of official conduct. Prosecutors are likely to argue that the most serious allegations were private efforts aimed at retaining power through political means, not lawful presidential duties. Each side knows what's at stake. Not only the criminal case, but the meaning of presidential accountability itself. Meanwhile, the political calendar keeps moving. That's another reason this ruling hit like a bombshell. It arrived in the middle of an election cycle already full of tension, distrust, and non-stop legal theater. So the public isn't just watching a constitutional debate. They're watching a constitutional debate collide with campaign season in real time. And that collision creates confusion, because legal reality and political messaging are not the same thing. A candidate may call something a total win. Opponents may call it proof of lawlessness. Cable news may cut it into the sharpest possible soundbite. But the actual ruling is more precise, and in some ways more explosive, because it doesn't end the fight. It redraws it. Official acts? Protected. Private conduct? Exposed. Everything now depends on where the courts place the facts. That's the sentence people need to keep in their heads as this unfolds. Because if the allegations tied to the fake elector effort, pressure on state officials, campaign-linked legal planning, or certain January 6-related conduct are ultimately classified as private, then this so-called win starts to look much less complete than it first appeared. And if that happens, the celebration we saw in the immediate aftermath may be remembered not as the end of the story, but as the moment people misunderstood what story had actually begun.